then I'll pass over to Richard.
Thank you very much indeed, Emma. Yeah, thank you everyone for joining again. So I'm just going to introduce Roots to Justice and our speakers this morning. Roots to Justice is, as you probably know, those you were on the last Taster session, it's a new legal empowerment initiative working in partnership with grassroots activists and organizations in Latin America, Africa, and Asia, who are supporting their communities to tackle corporate abuse and malpractice. Its aim is to connect legal specialists, the activists themselves, and civil society to build networks, share legal knowledge, and identify legal solutions, and so to build a more legally empowered and resilient community. So this is the second, as we say, taster webinars. The last was on free, prior, and informed consent, and the next will be on evidence gathering in tackling corporate abuse. The recordings of all of these tasters will eventually be available on the Roots to Justice website. This will then lead on to a best practice forum, which we're very excited about later in the year, and that will cover a range of themes and issues to identify practical legal strategies and to test alternative approaches to tackle corporate corruption and uphold environmental protections. One of the aims of Roots to Justice initiative is to pool legal knowledge of corporate and commercial lawyers who have experience engaging with corporations through private practice to help defenders better understand how they work and to what standards they need to be held accountable. Basically, the responsibilities for companies to adhere to ethical standards needs to be kind of more widely known, and the multiple ways in which lawyers can work to tackle corporate corruption and abuse through litigation or campaigns and activism, is something which is really growing. My particular interest, one thing that I'm particularly interested in, is the lawyers actually now joining activists and becoming activist lawyers, which means demonstrating and protesting and changing the law more quickly than just through the courts and through cases. There's a recent book which has just been published, which I'm reading through, which is really interesting, by David Renton, called Against the Law. You might want to see that. The other thing that I just wanted to say from my personal experience is that this is a door which is already ajar and which can be pushed open because of the ESG emphasis. ESG is now absolutely rampant throughout the corporate sector, and even if companies don't, or they say that they don't adhere to ESG, in fact they do, because they know that their customers require it. So two particular interests of mine that I will be following through. Let me introduce the speakers. So Richard Lord KC is a good friend and a colleague on a number of matters over the years. He's a very senior barrister from Brick Court Chambers, and he's also one of the founding members of the Roots to Justice initiative. He's a specialist in commercial litigation and international environmental claims, and he's going to talk to us this morning about the sources and the content of human rights obligations of companies, and then he's going to outline where the human rights issues arise for business in employment, labour issues, environment, climate change, etc. And then so be able then to discuss with you. And this is an interactive session, so please do put any questions in the chat, and they will come up later on in the session to discuss the key sources of law relevant to making human rights challenges in finance, health and safety, etc. Our second speaker, Jessica Binwani. Jessica is a Malaysian lawyer. She has her practice, which is personal injury and civil litigation, and she is also a particular specialist in law pertaining to indigenous land rights. She is going to present us with some stories and some case studies. One is related to a timber certification case, and the second is relating to fishermen's efforts to protect their right to life and environment. That's all from me. That's the introductions, and now over to you, Richard Lord and Jessica. Thank you.
Thank you, Richard, and thank you to everyone for joining us for this taster session on human rights obligations of companies. I'd stress what Rich has already said. This is a collaborative session. We've deliberately called what we're tasting is a best practice forum. It's a forum, not a lecture hall. We see this as a learning exchange between us all on how to use the law to hold companies to account. There will be people listening who have as much, and in many cases more, experience that's relevant than at least me. And so that's the spirit of this session. The main objective for me is to give a very short overview in about 20 minutes of a very big subject. And in trying to do that, I really want to do two things. One is to outline some of the sources and content of what may be called human rights obligations of companies. But the second one is perhaps more important, because anyone can go and read some of the instruments but the second one is to make it clear that legal enforcement of human rights obligations of companies is potentially very complex. It's not simply a sort of mirror image or a close relationship of enforcement by individuals of human rights in actions against states, which is something many of us are very familiar with. We want this to be a practical session, not a theoretical or academic one. So the whole point of this, not to discuss draft treaties and things, but to say, well, how might what we're discussing today be a thinking step, a learning opportunity to hold companies account in practice. But before I go on to anything more substantive, such as the UNGP or other instruments, I'll pause because what do we actually mean when we're talking about human rights obligations? And apologies if this is a quite legalistic point, but it's very important to distinguish between obligations that may be set out in sets of principles or codes, and those which are set out in a law or part of a law which you can actually use to go to court. And so the good news is, or the encouraging news is, it's very clear from all the litigations going on around the world that companies do have legal obligations in relation to a whole range of human rights that are susceptible to court action and other action. The less good news is, as I say, it's a complex issue in working out how best to deal with that. And we're very used to talking about human rights, which may be enshrined in a country's national laws or constitution. And so if there's a right to non-discrimination in a particular piece of legislation or the country's constitution, then when someone's discriminated against, you go to the, or either in a law that's discriminatory or in a public policy or act of a public body, then you can go to court as a matter of general principle and attack the law as contrary to fundamental human rights, or attack the policy. But one might think that if there is an infringement of human rights and it's caused by a company, one could do the same approach. But actually, it's much more difficult than that. And although there are and apologies if this is something known to everyone on the call, but on the whole, you can't just go to a court and say, well, I've got a human right to life or dignity or safe workplace enshrined in an international convention, and you, the company, are responsible for infringing it, and therefore you're liable. And again, before going further, in what context do human rights arise for businesses? Because business covers a huge range of activities. Human rights covers a huge range of rights. And as I see it, there are four areas that crop up constantly, main areas as well as some other ones. First of all, employment and labor issues, working practices, obvious scope for breaches of human rights in relation to some of the labor practices adopted by companies, not just big companies, but obviously the multinational companies tend to be those most focused on. Secondly, environment and the impacts of a whole range of corporate activities, particularly extractives, agribusiness, and infrastructure projects clearly have a wide range of impacts on the environment in all sorts of ways, pollution and deprivation of water and all sorts of things on the environmental side. Thirdly, and I don't know whether this is a subset of environment, I think of it as a separate thing, climate change. Climate change has been a big topic that I've been very interested in legal terms for quite a number of years now, but it's really only in the last 10 years that a lot of human rights actions are focused through the human rights lens, including important cases against corporates, and there are cases ongoing against, there's been a very well-known one against Shell, which brought in human rights elements, another one against Total, and so on. Fourthly, land issues, and of course all these things are related, but very often the operations of companies in all sorts of ways impact on land rights, customary land rights, and indigenous people particularly badly affected. And then there was a host of other things I don't want to dwell on, but things like consumer issues, also data issues. I've said maybe they're more minor, but probably one to watch in the future with the debate and concerns over big tech and the algorithms. And now isn't the time to dwell on the detail again, but listening to some of the debate about tragic suicides of teenagers who've been driven to unsuitable sites by big tech algorithms, one can see, and someone may pop up and say, well, there are already actions, but on human rights to life in relation to some of the data and privacy issues. And then the flip side of the topics, well, what are the rights that we're talking about? And again, one could fill not only 10 or 20 minutes, but a whole day with the range of rights. But some human rights are very obviously recognized in a whole host of contexts. The right to life, of course, but liberty, security of person, freedom from slavery, which feeds into forced labor, arrest, detention, and fair trial. All these things are in the International Bill of Rights, or the UNDR, however you prefer to call it, freedom of assembly, those sort of things. But often business activities impact on what might be termed second or third generation human rights, ones that are less often recognized universally and internationally, and in particular, rights to dignity, right to a clean environment, property rights, rights to health, rights to water, all of those sort of things. So coming on to that, and I think I need to speed up a bit because that introductory session seems to take up about half my time, but what are the sources? And this is perhaps the most key thing. Where are you looking for human rights? And the most important place is in national law, because if something's in national law, you can actually enforce it. And again, a key point is that many of the most important human rights obligations of companies are not in laws which have human rights in the label. So when you're looking for taking action of this type, look generally. Don't say, oh, I must go Google Human Rights Act. So national law, I suppose the example that's very much admired and other countries are seeking to replicate is the French due diligence law. Again, it's not called human rights, but this is a French law which applies to large French-based multinationals, and there's a threshold for size of employment. But basically, the French law requires those domiciled in France to take care in relation to their operations, globally, their own operations, those of their subsidiaries, subcontractors, suppliers. They may be required to produce a vigilance plan, and if it's not satisfactory, they may face a penalty and actions for damages. And I would suggest that that is the sort of model law that many people are trying to replicate, but that's a law with actual teeth that is being used. But not many countries have that type of law. So where else are you looking? Well, often things like health and safety legislation, it may not be called human rights, but it's often easier to allege a breach of, say, in English terms, the Health and Safety at Work Act, than to say, well, this company has infringed my right to health. And similarly, with most countries have a well-established law of tort or delict or wrongdoing, and where you get corporate activities that involve violence towards demonstrators or people protecting their environment, as often happens, you may not need a Human Rights Act. You may say, well, the law forbids assault or violence or using unreasonable force. Similarly, national laws, discrimination laws. Again, many countries have anti-discrimination laws and so on. So I'd suggest that when one's looking to take action, that's the first place you look, national law. Now, the second place to look is in international or regional codes. And the most obvious one and very much celebrated is the United Nations General Principles on Business and Human Rights. And again, I could do several talks just on that, but it's addressed to companies and states, but it's not legally binding. And before I started doing this sort of work, I thought, well, if something's not legally binding to a lawyer, is it any use? No, surely not. And I have learned that that's not the case, that even where things are not directly legally enforceable, they may be very relevant. Often companies will respond to allegations that they are not upholding standards set out in codes or internationally endorsed principles, even if not legally effective. Often the battle is not about whether something's legally enforceable, but whether the company is actually doing what's alleged. But although these principles are difficult, if not impossible, to enforce directly, they are very relevant to the sort of standard of care that may be expected of companies under national laws, although these principles themselves tend to be at a very high level. And if I have time, I'll come back to the UNGP, but as many of you will know, there are three basic principles: the state's duty to protect by enforcing laws, and note the main obligations enforcing laws and monitoring companies, it doesn't go much further than that, and corporate duty to respect human rights. And again, it's at a relatively high level. So very often the debate isn't about whether there is a general, the company doesn't say, well, I don't care about human rights. Some do, of course. And again, pausing a point that's important, when one's talking about holding corporations to account, as Richard Dighton is no doubt very familiar with, there's a whole range of corporate attitudes. There are some that adopt best practice. There are some that aspire to it. There are many that are guilty of what would be said greenwashing. They have high-sounding statements, but have no intention of abiding by those. There are some that try to, but don't know how to. There are many that do the right thing in their boardrooms in Europe and tick the right boxes in Europe or America, but either through ignorance or negligence are unaware of what happens in subsidiaries. And there are some, of course, that just say, I don't care, I'm just going to make as much profit as I can, and I really don't care about human rights. But it's very important to recognize that spectrum of attitudes. I deal with a lot of businesses. I don't subscribe to this view that all civil society actors are angelic victims, all corporates are evil, profit-grabbing people. There's a whole range of points, and that's important to bear in mind. This isn't a moral lecture or discussion. It's relevant to how one can take effective legal action to recognize these points. But why that's relevant is that the corporate duty to respect may come in various guises, including through contracts with corporate suppliers, tort law, company law, and so on. There's lots of other international principles. There are declarations by the International Labour Organization, so particularly well-known ones are on Declaration on Fundamental Principles and Rights at Work. There are declarations on conduct of multinational enterprises addressed to host governments, the enterprise themselves, and employer organizations. There are the OECD guidelines on business and human rights and the system of reporting contact points. And again, I don't want to be in any way disparaging of these instruments. They are really important and they do get used, but it's important not to be too optimistic about how helpful they can be to individuals, communities, activists, lawyers in actually taking practical action. And as I've said, most of the principles are couched in quite high level and don't get into the granularity of what human rights they are talking about and what a business must do. Very important, I think, from a practical point of view, is where a corporation either states on its website or in its policies that it abides by a set of principles, or is a member of an industry body which says so. So you may get a multinational oil company saying on its website, we endorse the UNGP and abide by it. Now, that doesn't make them legally binding. It doesn't mean that just because they've said it on their website, that becomes legally binding, but it is a very powerful weapon, and certainly cases I've been involved in, it's been highly relevant, because if they say that to the world, and then they say, oh, well, actually, it's not legally binding, a court may say, well, when we're looking at what's reasonable conduct for you under more general laws, and you've said you abide by these, how come you're now saying they don't apply? And often a company may be a member of a trade association, whether it's Associated Petroleum Institute or whatever it may be, or a roundtable on sustainable palm oil, and they may subscribe to sets of principles, and that, of course, is also important. And finally, in this broad category of obligations, you've got obligations imposed by lenders and international financial institutions, such as the IFC performance standards on environmental and social sustainability, some of the World Bank criteria. Of course, they're not universally liked or admired, Some people say the World Bank is really a charter for more corporate malpractice than already exists. But again, this isn't a political debate. The fact is that an effective remedy for corporate malpractice is often by reference to stakeholders such as banks or international financiers. And that's been proved time and again. Before my time is up, I think I've still got 5 minutes actually. But go to just the UNGP in detail, despite its limitations, as I say, as a practical tool. There's the obligations on the state in chapter 2, chapter 3, the business section. So the key point is that businesses under Article 11 should respect human rights by avoiding infringing them. So in any sort of case or claim involving that, you've got a twofold test. First of all, are the rights infringed? And that begs a lot of factual questions. What are the human rights that are sought to be infringed? You've got to pin them down into some sort of national law or international law. And secondly, they've got to be infringed by the activities of the business. So again, big causation test, because lots of businesses say, well, you may have been displaced indigenous people, but it's not us that did it. It's the government edict to declare this a national park or something like that. And Article 12 is important because it defines human rights in terms of the core international instruments. And as a minimum, the International Bill of Rights, of Human Rights, and the ILO Declaration of Fundamental Principles of Work, that covers freedom of association, collective bargaining, forced or compulsory labor, abolition of child labor, elimination of discrimination, safe and healthy working environment. But again, the Article 12 definition leaves a lot open to the debate because a lot of the human rights relied upon in a business context are not in those core instruments. There's all sorts of other ones. So one thing I want to mention in passing is perhaps not strictly within the subject of this short talk, but is increasingly important. And this is the point which has been below or above many people's radar, and this is investor-state dispute and investor-state arbitration. I mention this just because what's really important is because of the presence of private arbitration written into investment treaties, companies may resist effective action on human rights, because if there is redress in a national court saying you must stop expanding this mine because it's impacting on indigenous rights, and I'm picking an example from a case in Colombia, the company turns around and says, you, Colombia, in making this ruling in breach of the investment treaty between me and my host country and you must pay lots of compensation. And that is a potentially, it may not be of direct concern to those on this call looking to enforce rights, but it is something to bear in mind. And so I close by saying that when we look at what's happening on business and human rights, there's an awful lot of effort going into international conventions, EU directives, other national laws like the French one. And when we look at what a recent call, to take an example by an NGO active in Colombia, called for on business and human rights, it called for two things on the Irish and English governments. It said, first of all, we need legislation to hold companies accountable. And secondly, we need termination of the arbitration mechanisms in bilateral investment treaties. And that's a recognition of the difficulty in direct enforcement of international conventions. But as I say, the more encouraging news, as Jessica is about to illustrate, is that you can hold companies accountable by using some of these national laws and mechanisms, even if they don't have a human rights label on that law. And I think, apologies for going on too long, but it's a big subject and I get carried away on it. And yes, a final point. When I did a quick look on the one that, and I would endorse, there are loads of sources, but Business and Human Rights Resource Center is excellent. And when I had a quick look at, for example, just to illustrate the point of the recent 35 or so cases, I happened to find them in Africa because there are fewer in Asia, on business and human rights against corporates. The vast majority of them were using national laws and not instruments. Anyway, I keep promising to stop and failing to do so. So I will, without more, hand over to Jessica, who's actually got some real life case examples, which are of much more direct relevance than my general remarks.
Thank you, Richard. And hello, everyone. I'm happy to be here. And I just wanted to, first of all, start off by saying that I'm not an indigenous land rights specialist, but I have I've done some indigenous land rights work. And I started off with a lot of public interest work, and along the way went into full litigation and continue to do public interest work. So in the public interest work that we do, we've taken on cases representing communities who fight battles against corporations, and as well as governments who have worked alongside corporations to promote or to propose projects which have in effect affected the fundamental rights of the communities that we represent. So my job today is to take you through a couple of these cases and to let you know how we dealt with these cases in the way that Richard said just now, where you look for human rights aspects in your local laws which may not even say anything about human rights, but which are compliance with which would result in a recognition of the rights of the communities that are affected. So in the first case that I wanted to discuss, so in Malaysia, what we have is we have a lot of forested areas, which are especially the eastern part of Malaysia is largely covered by tropical forest. And what we have is a process which has been introduced in 1994, actually, in stages. It's called a management certification process, where it is part of the government's commitment to maintain forest resources. That's what it says. So the management certification process is carried out in accordance with the Program for Endorsement of Forest Certification, which is an international level forest certification program. So in order to, so basically, the activities of companies within forested areas must be certified, must undergo a certification scheme, and timber produced out of the certification scheme can then be marketed. Now, and they have to comply with ITCO criteria and indicators for sustainable forest management and various other forest management certification processes. What happened recently in the past couple of years, there was a particular, there have been, over the years, there have been issues about the certification process. But most recently, what happened was that communities, indigenous communities affected by the forest certification process. So during the COVID pandemic, there were a few companies, corporations, local corporations, which then decided to, well, the allegation of the communities is that they rushed through the certification process during the COVID lockdown. A certification process requires the company to conduct proper consultation with the affected indigenous communities. In fact, under the guidelines and the requirement for the management, the indicators, the criteria and indicators, the forest management unit managers, the companies, effectively have to take actions to ensure that their activities comply with or are carried out in the spirit of the UN Declaration on the Rights of Indigenous People, among which the principles of free, prior, informed consent are carried out, and then their FMU managers are required to take effective consultations with local communities. They're supposed to be consulted on their legal and customary native rights to the lands, which lands are essential to their survivals, the application of their traditional knowledge, and also to look into what is fair and equitable compensation for use of this knowledge. So, and there are various criteria which include participation of communities and consultation, not only regarding the land rights, but regarding the use of the lands, the indigenous lands, what are the areas of significant importance. So basically, the entire exercise is meant to identify, to consult with, and to recognize indigenous land rights. This process, according to the people who are directly affected, the indigenous communities directly affected by the certification process, was not complied with by the company, and that certification was rushed through. So a complaint was made to an NGO called which human rights defenders, a group of human rights defenders, and this group of human rights defenders then published a series of articles on their website, highlighting the concerns of the indigenous peoples communities relating to the certification granted. Certification was granted to the projects. So the articles reported that the concerns of the indigenous community, that the certification process was carried out in a rushed manner, that the communities were not given the opportunity to be adequately consulted, and were not given a real and authentic opportunity to give their free, prior, informed consent or withhold the same. So basically, the concerns were all recognized and were written out in a series of articles. So what was the company's response? The company filed a SLAPP suit. So for those of you who know what a SLAPP suit is, it is called Strategic Litigation Against Public Participation. Essentially, the company filed a libel suit against the human rights defenders who highlighted these violations in their articles. A SLAPP suit was filed. Now, before the SLAPP suit was filed, the community also filed a complaint through the Certification Council's dispute resolution process. So a complaint was made by the communities first, and then the SLAPP suit was filed. But right after the SLAPP suit was filed, the Dispute Resolution Committee informed the indigenous people that they were unable to deliberate on the case as a result of the SLAPP suit, because they didn't want to be seen to interfere in the lawsuit. The indigenous people communities went further. They submitted a formal complaint to the PEFC, which is the umbrella body. But even the PEFC said that the unfinished investigation locally was a barrier to it carrying out its own investigation. So what was the effect of the SLAPP suit? Effectively, the SLAPP suit amounted to a form of intimidation against the human rights defenders as well as the affected communities. And on top of it, it also resulted in the community's recourse to the local dispute resolution process to come to a standstill, which was so in a way, in an indirect way, the company gets to go on selling and marketing its certified timber, despite the fact that the issue of certification is still a live issue before the certification body. And the issue of the validity of the complaints of the community is still a live issue before the courts. So this case highlights a few things. I think one is that the community utilized effectively process, or rather not, they utilized the local process, which was the dispute resolution process within the certification process to challenge the certification, which was affecting their rights. Unfortunately, the slap suit is a tactic which is often used by corporations to silence those who speak out against corporations for the wrong thing they do. This is something which corporations need to take into account. And when you're talking about due diligence by corporations with respect vis-a-vis human rights, this is an area that is recognized as being a step which should not be taken. Corporations should engage, in carrying out their due diligence, ensure that the affected voices are heard and complaints and grievances addressed, dealt with. However, the knee-jerk reaction of the company in this case is a matter to be concerned about. And in fact, the indigenous communities also reported the matter to the special rapporteur on the human from the UN regarding this issue, and the matter has been brought to the attention of the government. So that's one case that I wanted to tell you about. So we had so this is how the human rights angle in this particular case was dealt with, and the kickback, not kickback, but the result that happened, which we are still fighting, and which we will continue to fight. The other case that I wanted to talk about was a battle by a community of fishermen against the loss of their fisher resources. So in a particular island in Penang in Malaysia, there is a plan by the local government, the state government, together with a consortium of companies to reclaim land, reclaim 3 artificial islands in the size of 4,500 acres in the south of the island. And this project, or reclamation project, will take about 15 years to complete. But what disturbed the communities was because there were 2 angles to it, two human rights angles that, aside from the many other issues that arose. One was the community, the EIA was issued. The EIA was, originally there was an EIA, and the EIA was approved. But look at the EIA showed that, first of all, the EIA had not adequately considered the effect of this reclamation, this massive reclamation project, on the loss of the fishers ecosystem, fishing grounds, turtle landing grounds, and the coral reefs, and the loss of fishery resources. And there was no consideration of how the project would undermine Malaysia's commitment to the United Nations Sustainable Development Goals. So there was huge concern about the effect of this reclamation in environmentally sensitive areas and the natural habitats of 2 very important turtle species, as well as various fishery resources. The second area that was a concern was the loss of life and livelihood of the fishers. Now, there was no proper cost-benefit analysis carried out in the EIA regarding the loss of livelihood of the fishers and the loss of damage of the fishing areas. What was merely touted in the EIA was trade-offs and sort of offsets. There was no real analysis as to whether the offsets were feasible and whether they adequately address the loss of life and livelihood of the fishers. There were no studies on the efficacies of the programs and whether these would actually result in restoring the fishers' rights, which would be seriously impaired by the project. So what did we do? What did the community do? The community and basically we assisted the community and we challenged the EIA. So this was an interesting approach to take because an EIA report had not been challenged via an appeal process, which was provided for in the law. So the law provided an appeal process. Once an EIA is approved, an aggrieved person can appeal against the approval of the EIA. We exercised that route. That was the first thing. And in the process of exercising the route, we invoked the planning laws. The planning laws required the EIA approval to ensure, to look at whether the project was in accordance with development plans in force. And it was found that the project was not in accordance with the development plans in force at that time. And that was raised as an issue with the Environmental Quality Appeal Board. The appeal board agreed with us and the EIA was thrown out. So this is a way that we utilize the local laws, the EIA laws, as well as the planning laws to deal with non-compliance with legal requirements, which in turn, of course, had this objection not been allowed, then the fight would have gone on the inadequacies of the EIA report and the problems that the fishers would face, as well as the loss of the environment and loss of fishery resources. That battle is still ongoing because the project proponent has now submitted a new EIA report. And while that EIA report is being considered by the Department of Environment, we have the community and NGOs have also given their feedback on the EIA report, which we say once again is inadequate because it's failed to deal with the loss of livelihood and the environment, which will result as a result, or which will happen as a result of this massive project. So I'm not sure how much time I've taken, but what I wanted to round up to say is that to utilize international instruments, as Richard pointed out just now, is very complex, but it is very useful to look at all the local requirements and the laws and the planning, environmental, health and safety, labor requirements, everything that has to be complied with by corporations, to see where they have fallen short and challenges to be taken in respect to this, which is also a form of, which is also a challenge to restore the rights of the people affected by projects or activities which affect them. That's all I have to say for now, and over to you, Jeff. Thank you.
Thanks very much, Richard. Thanks very much, Jessica, for those insights. I think we can move now into the Q&A. So if you'd like to turn your cameras on, if they're off, and unmute yourselves if you have questions for Richard or Jessica, or if you can't or don't want to do either of that, then feel free to put them in the chat and we can feed them in.
And Emma, sorry to interrupt, but as well as questions, I would welcome people's own experiences and stories as well, if they've got them.
Any reflections? Mm-hmm.
Sorry, I mean, I don't know if the speakers wants to share some reflections. I have a question that I would like to put forward to Jessica and to Richard. And I mean, it's a little bit of a simple question, but I'm really trying to think of very grassroots sort of activists that might be faced with, you know, similar situations than the one that Jessica has described. And I just wonder, you know, what are the kind of questions that themselves as activists should be asking before they sort of decide, you know, which is the best legal strategy I should be following? Because, you know, of course, there are loads of possible options, you know, local, national, regional, international. And I just wonder, you know, are there other ways in which activists themselves can be helped, you know, in the way of thinking about, you know, which is the best legal action to take next. Thank you.
Richard, you first.
Well, I thought, Jessica, well, I'll just make a couple of general points, which the three general points I'd make are, first of all, a lot of these type of actions are quite complicated and quite a challenging undertaking, and it will almost always involve a team effort of local activists, political and media campaigns, perhaps international partners. And so it's something that you want allies, and there are plenty of people around the world who can help on that, but you need to have a partnership. It's quite difficult to do on your own. The second point I'd make is that gathering evidence at the outset is really important, because if you're going to make a complaint, and perhaps to the parent company of a local company, the more evidence you've got to start with, the better, because quite often, once these complaints are made or actions are started, the company may go into defense mode, deny everything, and so on. And also, very often, those at the head office level are genuinely unaware of what happens on the ground. And quite often, it's not just greenwashing, it is genuine shock when people in head office get a video or credible testimony as to what's happening in their garment factory or their mine or some other project a long way from head office. And so I think gathering evidence and detailed facts as far as possible at the outset is important. The third point follows from that, is look internationally. And very often the human rights violations are committed in a country where it's difficult to obtain redress, either because people will be shot at or imprisoned or slap-suited if they do, or because there's no judicial access to justice. But it's possible to bring in, oh, sorry if there's feedback, to go and bring action in Europe or the US against either people in the supply chain or stakeholders or parent companies. So I've been involved in cases of that. So the three sort of broad level tips as to how to go about thinking. But we're not suggesting that obviously just an hour seminar will enable activists to go off to court, but those are the sort of thinking steps that I would suggest.
Thanks, Richard. Susie, what I feel that we need to start with us, in addition, is examining as I mentioned earlier, the locally applicable laws. A lot of opportunities are available through the local legal mechanisms, the legal setup, because along the way, maybe you say 20 years ago, a lot of the laws may not have had, for example, redress mechanisms or local procedures, appeal procedures. Now, most planning, environmental laws do have processes, and it may be useful, and it's definitely a requirement if you're going to go to court to first exhaust your domestic remedy. So it's useful to know what are the procedural requirements that companies have to comply with in order to get their approvals from the government and so on. So for instance, we have in our planning laws in Malaysia, we have a required particular kinds of projects. We have a National Physical Planning Council, which is a high-level council at the federal level. So when states or in regions in other countries want to approve particular kind of projects which have huge impacts, they have to get the advice of the National Physical Planning Council. So this is a relatively new development in the law. But what has happened is that we've got companies which have managed to push through approvals bypassing this process. So now we are actually in the middle of two different challenges against two different companies, challenging the approvals they've obtained without this consultation process. So you don't need evidence, you don't need the evidence of what is happening on the ground, scientific evidence for this. It's purely the law, and it's useful because then you stop them before they even start. So you challenge all their approvals. So it's really quite useful to know your local laws well, and to look for loopholes, to look for opportunities to challenge corporations through these local instruments. The second thing is what Richard did also mention was to look at the company involved, if it's an MNC or transnational corporation, to look at their setup and their holding companies and the country of origin of the holding companies. As Richard mentioned, sometimes the holding company doesn't know what's happening with the subsidiary in a country. So then you look at the country of origin and whether the laws in the country of origin have particular limitations or requirements that companies have to comply with in relation to their activities in other countries. So it's useful to raise these issues, to investigate these issues, raise them with the parent company vis-a-vis the laws in the parent country. And also useful because shareholders in the parent country may also not approve of what is being done by the subsidiaries in another country. Also, another area that people could look at would be the requirements by securities commissions. In Malaysia, we call it the Security Commission, in other countries, different things, on what listed companies can or cannot do. Security regulatory bodies are able to examine and look into the activities of companies listed on the exchange. Yeah, these are some of the questions I think would be useful to look at in any case.
Great, thank you so much.
So just Jessica, can I just follow up on that? So for example, if you were interested in permits, right? So I think you discussed about having a, going to a planning authority. So if you're looking at, from the power perspective, where these decisions are made, right? And it's at the planning, at the permit, at the permit stage when permits are handed out. How would, and I totally get that as a really effective rule of law intervention point. How would actually lawyers do that, right? How would they, what would that look like? I ask because I've been doing one project in working on a project in Indonesia, and one of the interventions there that has been really successful was on going to the anti-corruption and working with the anti-corruption committee, and through that they've been able to essentially, cancel a lot of the mining concessions that were illegally given out. So how would you how would that work in, in other countries? It's a kind of a preventative action, right? It's before the harm has happened, which is great. Yeah, I'm just interested to know how you would do that.
Well, there are a few ways. One is using the planning legislation, the route provided by the planning legislation itself. Some planning laws have got an appeal process, an internal, I wouldn't say internal, but they've got an appeal process in the law. So there's an independent appeal board. Once a decision is made, a aggrieved person can make an appeal to the appeal board. We have this process, but once we have a development plan in place, a development plan goes through the public participation process, and then after that, it's more or less carved in stone. So then the next step would be, if you find a particular activity doesn't comply with the development plan, and it is to challenge the approval by way of judicial review, which is also what we are doing in another case. The cases that I mentioned, we're challenging the planning permission granted to the project proponents in those activities in the form of judicial review proceedings in court, and stating that the actions taken, I mean, the planning permission granted is illegal because it failed to comply with the requirements of the law. So as I mentioned, like one of the requirements, refer particular kinds of projects to the national physical planning, or whatever you find that they have not complied with. The best one of the ways would be to file an action for judicial review of the planning permission, which is being done. So that in that you can raise illegality, and you can also look at the substance of the approval given. You can raise issues of unreasonable irrationality because you're looking at the substance of the approval, and your arguments would be why the approval should not have been granted in the circumstances of the case, and then you can bring in all your scientific evidence. You also when you file these proceedings, the fear is that the proceedings will take some time to complete, and then the project will continue as it is. So that's where your injunctions and stop work orders come in. And the effort has to be taken to try and put in place some sort of stop work order or injunctions, while you challenge the legality of the project, simply because an illegality cannot be allowed to proceed and affect people's lives irreparably. And then, after 3 years, if your judicial review comes through, the damage has already been done. So this is one of the ways that can be, that the challenge can be done.
Yeah, that's incredibly powerful, because if you're thinking through to financing, right, if a project is internationally banked, that permit will be the absolute fundamental upon which the project is going to get any financing. So if there's any problem with that, it won't happen. So that's incredibly powerful. Yeah. Okay, thank you.
If I may, I just pick up on that point from Kinari and Jessica. I totally agree. And it's an example, and I'm aware of cases, particularly in Africa and Latin America, where the same route has been used on the corruption side of concessions granted illegally or corruptly. And two perhaps obvious points. First of all, prevention is much better than cure. It's obviously much better and more important to stop an illegal project at the outset or in its infancy than be looking for injunctions and compensation or resettlement later. And secondly, where you've got a company that's procured a concession by corruption, it's much more likely that it's not going to observe other legal requirements once it gets going. But I would certainly endorse the importance of that sort of approach. And
Thanks, Richard. Thanks, Jessica. Any other questions or, as Richard said, comments and insights anyone wants to share?
I've got an additional question, but I'll be happy to be quiet if someone else from the audience wants to raise a comment or a question.
Please go ahead, Susie. And if anyone
Okay.
does have questions, please
Okay.
don't ask or put them in the chat.
Great, thank you. Yes, my second question is kind of connected to the what I would call the hierarchy of sort of legal actions or legal sort of systems or laws in place. So, you know, how important are those hierarchies when it comes to design a legal strategy by activists on the ground? Do they have to sort of, you know, exhaust the specific routes first at national level, or can they work in complementary ways, you know, at all levels? I mean, I just wonder if there is anything that needs to be shared with activists in that regard. Thank you.
Thanks, Susie, for the question. I don't see a need for a hierarchy. I think when you are challenging corporate impunities, challenges can be brought at all levels simultaneously. In fact, it is useful to challenge, use instruments outside of the country. So meaning that bring your challenges by raising issues with the holding company, with the other countries, with international bodies, while you are also pursuing your local remedies. This will, in effect, if attention is, you know, if the relevant bodies place attention, that it would create a bit of pressure locally for the corporations or for the local governments to comply with international human rights regimes. So, for instance, you're talking about like the case I spoke to you about, the one with the slap suit. So while the community pursue their grievance, the complaints mechanism within the certification process, they also, and while they're dealing with the slap suit, they also made a complaint, or rather the matter was also brought to the attention of the special rapporteur, and other international NGOs have also taken on this issue. So it is being approached at all levels. So it's good to have that going simultaneously, because then the corporation and your home country also knows that the world is watching. And I think it's very useful to have that happening at the same time, because if the corporation knows that you're standing alone and only doing things in your own backyard, it's not going to be very effective. I think that's the problem we have faced.
Thank you.
I would agree, but perhaps just add a couple of things. I totally agree with Jessica that opening multiple fronts in a campaign, whether one calls it a war or not, is a good idea. And there are projects that I can think of where there are local lawsuits in the local courts, and there are at the same time lawsuits in the country where the parent is domiciled, and there are complaints to the OECD and all sorts of other things. But the only qualifications I'd say is, first of all, it takes a lot of resources, and as in any other sort of campaign or war, if you call it that, you may want to focus on your best options. And the second thing is that in some instances, there is a question of exhaustion of remedies. And I think Jessica and I both agree that it's unlikely that local activists will have at the top of their list complaints to a regional human rights body or the UN Human Rights Commission or something like that. And one of the things that is relevant in this context, particularly for an Asian audience, is unlike Latin America and Africa, there's no regional human rights system, but some of those do require exhaustion of local remedies before you can go further. So those are the only two extra points I'd add to what Jessica said.
Great, thank you so much to both.
Great. Well, we've got a few minutes left if anyone has any final questions. And then I think if not, Richard and Jessica, if you have any closing thoughts or takeaway points you wanted to leave us with.
I think my takeaway point would be, if you're a human rights defender, or whether even if you're a lawyer working with a human rights defender, it's always useful to look at every single angle that you can explore in trying to deal with a human rights violation by a corporation, and not to limit yourself to what are the usual recognized ways of challenging, because when you utilize different mechanisms and mechanisms which are seldom utilized, which people may not know about in the local laws, you'd be pleasantly surprised at how successful they could be, simply because it's unexpected. So we realize that, so we think that these are very useful tools that can be used to challenge operations and the activities that we do. And we are happy to help or work with anyone who wants to get more information about these kind of things. Yeah.
Well, Jessica's made exactly the point I was going to make. So other than say I agree, I won't repeat it. The only thing I would say is we agree you look at all the angles, but that can be quite difficult and challenging to know what the angles are. And again, just websites aren't the answer, but there are lots of resources where you can go and look to get thoughts, and I think we'd be happy to, many of you will know of them. One of the things I'm involved with is Action for Justice. I've mentioned the BHRRC, ELAW, and those are really good starting points for thinking of angles and seeing what other people have done. So that won't, but no, I agree with Jessica.
Thanks very much, Richard, and thanks very much, Jessica, for your contributions. And thank you all for joining the second in the series of webinars hosted by the Roots2Justice initiative. We'll be hosting another webinar soon on gathering evidence in cases of corporate corruption. The date for that is still to be confirmed, but we'll contact everyone who's registered for this and previous webinars. And we'll also put it on our website and on our social media platforms. So I'm just putting the Roots2Justice website in the chat if anyone is interested in finding out more. These are 3 initial introductory sessions. We may host some more, but initially there will be 3, and that will lead us into a best practice forum later this year. And during that, we would like to host a range of topics, digging deeper into some of the ones we've covered and also others that have been suggested to us by defenders. And by all means, please do suggest new topics. We'd like to cover them too. And we'll also be using a range of ways in which we delve into those topics. So through case studies like we have today, through legal clinics, through drop-in sessions, and again, any suggestions of the sorts of ways you'd like to deal with some of these topics, we would really welcome. So please do get in touch. Richard, Susie, or I would be happy to chat with you separately offline about ways in which you can get involved. The last webinar that we hosted was on free, prior and informed consent. We have a recording of that, which will be up on our website shortly, and the recording of today we will send to the participants and also put up on our website. So thank you for all of your contributions. no further updates really from us, except if you're a defender, a lawyer, a possible partner working with defenders networks, please do join the network, join the conversation, and hope to see you at the next one. So thanks again to our speakers, and thanks to you all, and see you all very soon.